24, 6 o'clock p.m. This special meeting, the notices were sent out in plenty of time, and it was publicized as required by law. So in order to get started, as our custom, if y'all don't mind, let's take a stand and go to the Lord in some prayer. And then, Miss Sandy, would you lead us?
Heavenly Father, Lord, we just want to acknowledge our need for you tonight. Lord, we pray that you would be here and that you would feel comfortable amongst us, Lord, and that you would bless us. Continue to bless our parish, Lord, because we need your mercy and your grace upon our lives. Lord, may there be unity and peace, and may business get done.
Amen. Amen. Miss Caroline, you lead us in the Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you all so much for coming out on a Monday. Miss Sandy, would you call the roll to make sure we have a quorum here tonight?
Mr. Watts?
Yes.
Mr. Goff?
Yeah.
Mr. Mangus?
Here.
Mr. Taylor?
Yes.
Mr. Shavers?
Here.
Mr. Coates?
Here.
Mr. Wascom?
Here.
Ms. Sandifer?
Here.
Mr. Erdy?
Here.
Everybody's present.
A remote. I don't have.
Got that battle right there.
Sorry, I didn't see it. But I'm here.
All right. Quorum is present. The first item on this agenda would be to discuss a discussion of appointees of settlement panel for Ascension Properties, Inc. versus Livingston Parish Government. Just a quick update. At our last council meeting, we appointed a committee, or council authorized me to appoint a committee to work on negotiations for the settlement from Ascension, for the potential settlement for Ascension Properties. And at the time, we talked about it probably a little bit at the night. It was a quick decision, and I appointed some council members, but I believe that there's been some that have just said, hey, I appreciate the offer, willing to help, but I just can't do it, and I get that. With that being said, we don't necessarily have 3 council members I know that's going to be there. So let me just say, if there's any volunteers that want to go to a settlement, please speak up now and raise your hand.
Say something.
Ms. Sandifer.
I just want to explain that I'm officially pulling myself off of this committee. I needed to state it on public record. I informed the chairman Friday morning. I will not be serving on a settlement negotiations committee.
All right, and if there are no volunteers, and because of Ms. Sandifer being off, and I respect that as much, and this being her district, I am not going to go either. So unless someone else wants to volunteer, raise your hand now. If not, then we got a choice. We could either entertain a motion to just abolish the committee, or we could just let it die as it is. Is there a pleasure of this council for that?
I have a question.
All right, Mr. Goff.
I don't know exactly what all changed from the last meeting, and it's your district. I'm not sure why you haven't stepped down. Does our attorney even know that this is happening?
Yes, I informed him as well.
Can you come up and share whether we need to have this committee, or if it's a moot point, we don't have to have it, or?
What we need.
It sounded pretty serious that we needed it the last I heard in the last meeting. So go ahead.
The federal court has established a settlement process which we have been required to participate in. If we do not participate in it, the federal judge that has the case at the trial, which will be later in July, will likely take serious offense to it because we are ordered to have the settlement committee. We're ordered to participate in a settlement. In order to participate in a settlement, we need to have someone who has authority to act on behalf of the parish. The settlement process began with the Deer Run developer submitting a proposed settlement to us. It's many, 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 many pages long. We have drafted a response to it, and some of it's history, but the actual settlement part of it's about 4 pages. It's much, much simpler, much easier to understand, and obviously a lot better for the parish.
And we've given you all a copy.
And we've provided a copy of it. What I need is someone from the parish who will, A, give us authority to present that proposed settlement to Deer Run, and B, will participate in the negotiations with Deer Run just to see if perchance we can get some version of the settlement that we have drafted, adopted, or agreed to. The settlement that I've drafted is actually very favorable to the parish, and even incorporates some of the things that the District 5 residents wanted. So.
It was just put on my desk tonight.
Okay.
It was just created in the last 24 hours.
Yeah.
When we went into executive session, prior to that, we didn't have any information on what the settlement would be, and why are we forced to settle? Is that what's going on here?
We are forced to participate in the settlement negotiations.
That's the federal magistrate judge.
That's the federal judge has ordered us to participate in the settlement negotiations with the magistrate. When we had the previous meeting, all we had was the settlement offer from Deer Run, and we only got that day. We had not put our response to it together yet. I did circulate a history, which is actually a good bit of the document, though it doesn't have the actual this part of the settlement that the parish would propose in it. Today I spent creating the actual settlement that the parish would propose back to Deer Run. As I indicated, it's the settlement proposal I have created is much simpler than the one that Deer Run has proposed. It's actually in a lot of ways very favorable to the parish. It incorporates some of the things that the District 5 residents wanted, and I think if the parish could get a settlement like the one I've created, I think it would be very favorable to the parish, but obviously I can't present it until someone gives me authority to do it.
And here's the bottom line. We could have one representative from the parish with authority go to that settlement conference with us, or we thought 3 was a good number because it gives a little more of a cross-section. So that was the idea behind 3.
Let me ask a question. You had said that we were required or forced to participate in this settlement. Does that mean if no one shows up from this council that we're in contempt of court and could be arrested or charged?
Yes, sir. There's a possibility that if the council just refuses to appoint anybody, one of 2 things is likely. That would be one of them. The other possibility is that the court issues a subpoena for all of the members of the council and makes everyone come down there. And it's, like I say, there's no point in aggravating a federal judge. I mean, not that I haven't done it before, but I try not to do it. And,
do they have to be members of the council? Can we appoint other representation to this committee?
As long as you gave them the authority, I don't know that that's not prohibited.
Let me suggest this to you. The settlement proposal that I've created that's in front of you has basically 3 moving parts. 4 moving parts. The first one is that Deer Run gets a declaratory judgment from the court that establishes what everybody has admitted in the depositions that they have. That is just a recognition of the rights that they have. They have a preliminary plat that's not been challenged. It was properly adopted. They have construction plans that have been reviewed and meet all requirements. The only thing that they need to start construction is for the withdrawal of the stop work order, and that stop work order was issued because they had not paid fees, and the permit office actually didn't have a copy of the construction plans that were approved. All that part of it would be recognize that that's the case, which everybody's attested to in the deposition. Now the rest
That's the case. Why don't they just pay the fees?
We actually gave them a date for a pre-construction meeting of June the 20th. We sent them a letter telling them that all they had to do was pay the fees and they would get the pre-construction meeting. And I suspect for strategic reasons, they chose not to participate in that. If we have to try the case, that will be one of the issues that we raised, that we actually gave them what they wanted.
And I communicated that to their lawyer, and it's part of their settlement proposal that they would have the pre-construction meeting and pay the fees. That's part of their ideas of the settlement. I mean, the truth of the matter is that they want to get everything. They don't want to just get a pre-construction meeting and pay their fees and start work. They want to have some assurances that the rest of this is going to be buttoned up and that it's going to be solid after what they've been through with the prior settlement. That's public record, what I just told you.
He's right, but this proposed settlement agreement would come before the council twice to be implemented, and it would come before the Planning and Zoning Commission to be implemented. It does propose there to be a development agreement with Ascension Properties. Under the terms of the development agreement, the first thing that's got to happen is that the parish will have to pass an ordinance establishing the procedures to do a development agreement. What I'm recommending to you is that those procedures are that if a proposed development agreement is signed, that it be submitted to the Planning and Zoning Commission. You go through the standard Planning and Zoning Commission process with advertised hearing. You hear everything about it. If the Planning and Zoning Commission makes a recommendation to approve it, it then goes to the council for consideration. The council holds its own hearing on it, and the council decides whether to approve the development plan. Under the terms of this settlement, the first thing that would happen would be the ordinance would come in front of the council to create the process, and then the second thing that would happen would be there would be a proposed development agreement which would go through the process.
I think there were some council members that had some questions. Let's start to my left. Mr. Mangus.
Okay. In page 4E, from the document from Scott D. Johnson, United States Magistrate Judge, it says in bold, failure to...
Reading from the order.
I'm sorry?
You're reading from the order.
Yes.
That Judge Johnson gave.
Failure to timely comply with all requirements of this order may result in cancellation of the settlement conference and our sanctions at the court's discretion. So that's to your point that they could hold contempt of court, but it could also be that they just cancel the settlement, so it goes to court. All right, so there's that. It as to Ryan's point, Mr. Shaver's point, it doesn't say it has to be a councilman. I don't. Why you're our counselors? Why can't we just have you do that?
If the requirement is someone attend who has authority to bind the parish, if you want to give us the authority to do that and pass a resolution doing that, we will go as the party with authority to bind the parish.
We just thought, honestly, it was prudent to have some 2, 1, 3, 5 council members participate in that so that it came out the way, maybe not 100% the way that you wanted it to, but that you could live with it. And so that was the idea behind doing it, Mr. Wascom. And when I talked to you originally, that's what you and I talked about. So
is there?
I still have.
Oh, go ahead. I thought you were finished.
I'm sorry. Now, looking at the settlement, the two things stand out right away, but as Ms. Sandifer said, we just got this. According to number 1, I'm reading on the 3rd line, the amendment to the plat would not need separate Planning Commission approval because the development agreement would be approved after Planning and Zoning Commission hearing as set forth below. Yes. But it says that we have to accept the original one back on September 18th, 2023. The only amendment to that would be 62-foot lots. So this is still 2,000 homes. This is still
It would still be.
400.
Yes, sir.
I don't know if I agree with that. And then number 11 requires Livingston Parish will adopt, that's us, we will adopt an ordinance providing for the process for approval of the development agreement. So that means that we have to make this legal. So we don't just have to agree with it, we have to make it law.
That's setting up the procedure as part of the state statute under which this is done. So that is just a part, the legislature's created the way to do this, and that's how you do it. Now, as far as the plat goes, the September 18 preliminary plat that was signed by the permitting department on September 18 was done after a properly noticed hearing of the Planning Commission. It has not been challenged, and at this point in time, that preliminary plat is final. I mean, if Deer Run chooses to do it, they could proceed now, pay their $400, and bill what's in that preliminary plat too. $4,000 and bill the.
Well, why haven't they?
Because I think they want this entire matter resolved and reduced to a settlement in federal
But they want us
court.
to agree to it. I mean, it's one thing to do something, but we got elected, most of us, if I can speak for most of us, you know, trying to slow down and improve Livingston Parish, and this is more than just rubber stamping this, we're making it legal. That's a tough ask.
Should you choose to do so, I presented this in two sections. The first section recognizes that authorizes a declaratory judgment establishing the facts which have already been testified to in the depositions. Every parish official has testified to this, and that is that they have a validly approved preliminary plat, the one of September 18, and they have validly approved construction plans for the first phase of the development, and they're entitled to start with that. That is uniformly established in all the depositions. So another possible way to do this would be to say that the parish will agree to a judgment that says that. If you did that, you will not get the other benefits that I've put in the development agreement side of this, with the smaller lots, and there is a sunset provision in this after 3 years.
If you do that, you defer to the federal judge to write it the way she wants to. This way, we get look, let me speak just for a moment to the settlement
Did you have some more
process.
questions, John?
Last thing I want to say is,
Hold on one second.
if we do go to court, and maybe it's a Hail Mary, I don't know, but if we do win this, I mean, you're contesting this plat, right?
No.
What do you if we
There's
if we keep
justifying the stop work order.
if we keep the June 29th court date, what are the facts in that?
The fight is over the stop work order.
The fight's over the stop work order, not giving a construction plan, not holding a pre-construction meeting, and not rezoning the section that's got the townhouses. The rezoning of the property for the townhouses is not necessary. The federal judge has already entered a judgment voiding all zoning in District 5. The current proposal meets all the 2.5 lots density requirement for the parish ordinance, and the parish engineers already testified to that. So they do not need the rezoning that they put in their lawsuit. The not granting the pre-construction hearing had to do with the way that the construction plans were approved. That once they pay their $4,000 and change, that will be lifted no matter what. If we could try the lawsuit and totally win it, we could win everything in that lawsuit, and they could walk in the next day with a $4,000 however many dollar check, say, here it is, I want my pre-construction meeting, and there would be no stopping it.
Here's the elephant in the room. The elephant in the room is three things: equal protection, substantive due process, and procedural due process. The judge is going to decide whether those three constitutional provisions were violated or they weren't violated. If they're violated, then she has broad discretion. Look, Mr. Cashio's sitting right there, Mr. Perillou's right behind me. They know that federal judge got broad discretion to mete out, and I've said this before, I'm just saying it publicly so everybody understands what's at stake. It's easy to say, oh, Mayor Irving, y'all just go try the case. But this is what's at stake. She could render a judgment with big numbers.
Did you have any more else? Were you finished, John?
Mr. Sandifer, do you have a second? Yes, can you come up? Mr. Sandifer's on the master planning, right?
Sure.
You made a very salient point at the last meeting about the master plan. Can you reiterate that for us?
Up to the mic so we can hear you.
Mr. Magazine, when he's finished, I'd like to speak to the settlement process, just to give y'all a
Well,
little
that
bit
would be
more
time
background.
at the end. I'm
Yes,
sure
sir.
every council member has some comments, so.
All right, Jamie Sandifer, 24411 Oma Harris Lane, Denham Springs. Yes, I don't have the paperwork in front of me now, but basically there's a 2019 ordinance that states that any development decisions will be in accordance with the master plan from that point on, unless the master plan is amended. There have been no amendments to the master plan, and the master plan has that area, the area in question or deer run, identified as rural or agricultural.
That, I'm not a lawyer, but to me, any preliminary plat that was approved that went against the master plan would be against our ordinances and therefore non-valid.
I mean, I'm not an attorney, but from
And
where
I
I
don't
sit, it looks
understand
like
why
it
this
was
is not
approved
in the
error.
state court. I don't know how this got to the federal court. It seems like the state court should have jurisdiction. And Mr. Cashio, can you
He's fixing to answer it for you.
speak to why it's not state?
There is a
Mr.
master
Sandifer.
plan. The master plan is actually amended every time that there is an approval of the subdivision plat. It becomes an amendment to the master plan. So the master plan for this development has in fact been amended by the approval of the preliminary plat. That's one of the things that a preliminary plat is.
Which preliminary plat?
Time we do
The September 18 preliminary plat. I ignore the other two preliminary plats they have, even though they're proud of them, because neither one of them were approved properly. But the September 18 preliminary plat followed every procedure that I set out in my opinion letter written last year about how you do it right. So,
Is this the one that the parish president at the time signed the construction plans on with no?
Sorry.
no, that one's the one that's subject to a lawsuit by the 5th District. That one was not approved correctly. The proper hearing was not held. Subsequent to that one, they filed, and it's all recited in the history of that document. They filed a preliminary plat. This is preliminary plat 2. They filed it. It was advertised on August 31st, 2023, and there was a hearing held before the Planning Commission, and I don't remember if it was September the 5th or something, but the date's in there. I've checked. It was held. There was a hearing held before the Planning Commission. It was approved. And then Sam Girolamo signed off on that on September 18. That met all requirements.
Did you have?
I have something else.
Hold on, we got all the council members. Let's try to keep
This
it quick.
is an important
So go
point.
ahead. I'm going to turn the floor to Ms.
You know our laws.
I'm going to give the floor to Ms. Sandifer.
Okay.
So in the past, we have violated open meetings laws and are in litigation for that. And on last week's agenda, it reads, discussion including possible executive session to authorize Livingston Parish President Randy Delatt to both attend the July 10th, 2024 mandatory court settlement and to negotiate with authority before, during, and potentially after the settlement conference for a settlement. And then it continues on. It said nothing about us. And then we come out, and we haven't appointed him, and we come out and appoint 3 members of the council to go, which is an issue with state law, which we've already been around that. We're familiar with that because we violated that as well in the past, and it's got to go. Once the negotiation is made, it comes back, it goes in the official journal for 10 days, and then it has to come before a public hearing so the public can be heard, and then the council takes a vote. But we're not even following what we had on the agenda, which has been a problem in the past.
It has been a problem in the past. I don't think that's skewed enough to make it a problem, but the difference between appointing the parish president and appointing a committee. But in any case, there's no, the chairman has authority to appoint a committee. So he can
But
appoint.
that's not what was on the agenda, is what I'm saying. We've been called out on that before, quite a few times.
We believe he can appoint a committee whether you go into executive session or not. He has the authority to do that.
Even if it's not on the agenda?
Yeah, he can. He doesn't even need to be in a regular meeting to appoint a committee. He can just.
I've always practiced that.
Yeah, exactly.
Let's start over here. Mr. Coates, did you have something? Taylor, Coates, let's go and see. We'll come back this way.
We talked about the District 5 citizens and their court case. Is that still going forward?
There are 2 District 5 citizens court cases. So I'm going to take the one that's the most dormant right now first. There was a suit that was a mandamus proceeding that had to do with the fact that the parish was not following the procedures that were set out in the zoning, planning, everything.
Mr. Irvin, excuse the interruption, but I'm going to cut you off because I was really just asking for a yes or no. And the reason I'm asking for that is what happens. You've already said there's 2 suits out there with District 5 citizens.
Right.
And I don't want to deny them their due process either. So what happens if we settle to their cases?
The case that is pending, which has a summary judgment proceeding that's set in August, is a challenge to the approval process for the settlement agreement that was entered into on July the 28th last year. So the settlement, it would void the council's approval of the settlement agreement that was entered into July 28th last year.
If you settle this case that we're working on right now, all that's moot.
That's what I thought.
All that's moot. You have the power to resolve this matter once and for all and wipe all that out. Because all those issues had to do with the prior settlement. It's not, this prior settlement's gone.
But if we do that, we're denying them their right to stop it altogether if that's what they're trying to do.
There is no procedure and there is nothing pending that's going to stop it, with one exception, which is actually preserved in the agreement that, in the draft settlement agreement I've got. There is another landowner claim that's out there. I don't have a great opinion, a high opinion that that's going to be successful, but one of the requirements for the development agreement that I'm proposing that you offer a settlement under is they have to have title to the property. If their title to the property fails, the settlement agreement, the development agreement fails because they do not have title, because that is a requirement.
But that has not been determined yet, correct? That's going through a lawsuit.
It has not been determined, but legally they are in possession of the property. They are the people who are paying the taxes on the property. They are the people who can go on the property and do things, and that puts them in possession of the property, and somebody who comes and attacks their title is going to have to prove, I think under the present law, that they have a better title than the one that the people in possession do, and I think it is extremely unlikely they're going to be able to do that, but if they do that, the development agreement would fail and it would be over, and there would be no agreement.
And at y'all's behest, Steve put that in our proposal back to them to cover that issue.
It's in the
Let's see.
in the
Were you
statute.
done, Mr. Coates? Do you have any?
I'm done.
All right, Mr. Taylor is good. Mr. Shavers, Mr. Aaron, you have anything else real quick as I go this way? Or just, Mr. Banks, I think you said you had one more question?
I just wanted, Mr. Cascio, as to what Mr. Sandifer said, does the master plan change every time there's a new preliminary plat?
So my understanding is whenever you are developing a parish, if you have a master plan in place, you can rely on that master plan when developments come up. But as developments are approved, it does act as an amendment and things change.
Mr. Goff, did you have anything else?
I have a couple things. Go ahead.
Mr. Lottie? No, you say you do or not?
Oh, I do.
Oh, you do? Okay.
So the nuts and bolts of this whole thing, whether we send somebody or not, or whether we give you the approval, I think someone or multiple people from this council should be representing this council at this
Settlement conference on July 10th.
We should not leave it in somebody else's hands not to have nothing to say there. That being said, let me see if I'm correct here. We do nothing. It goes to court, and we can get a healthy fine, because I'm about like the federal judge. I need this to be done, over with, and in our rearview mirror that I've said over and over again, standing right over there when we hired y'all. Sooner we get this to past us and complete it, the sooner this parish can move forward. This council and this administration is doing everything that we can do moving forward, not to have something like this happen again with our ordinances, our moratorium, etc. So unfortunately, this one was from that we inherited, and here it is. And unfortunately, as I understand it, it's going to happen. They pay $4,000, they go out and they get to work.
I don't think they paid that.
If they pay their $4,000.
Get their pre-construction meeting.
All they had to do is pay their $4,000.
The day after, Randy's testified, the day after they do that, the stop work order comes off,
Right.
and they're free to start construction
They just start construction.
on whatever they've got approved. On the phases they've got
That'll
approved.
be phase one.
Right. So that being said, they have the ability just to go forward. And this settlement conference brings us to the table and say, we want this to be nice, clean cut, just as much as y'all do, but we would have concessions with Citizens of District 5 is in here. And I thought y'all did a pretty good job of bringing in a lot of them and including the deal with Mr. Harris, etc. So if we do not go to that table and sit down, then we leave it in the judge's hands that has already said one settlement, and now we're going back to her again. And now she not only says, do it this way, but she says, pay this bill. I don't really understand a real big difficult choice or decision here. I really don't. And it's a federal judge that says we need to not, would you be a part of this conference? It says you will be a part of this conference. You will make this happen, because she don't want to see it no more.
Can I speak to the conference just a second? This is important. The conference is not anything unique to this case, guys. Any complex case, moderately priced case over there, the federal judges use the magistrates with their talents to try to have these settlement conferences to resolve issues that can be resolved before they get to trial. That's just what this is. This isn't anything that they said, oh man, we're going to just make Livingston Parish come participate in this. It's a cookie cutter. It happens in a lot of cases in federal court. And so this is nothing unique. And so, but it does have the ability to bring the parties together with the authority and the weight of that federal magistrate judge in that open courtroom and talk about the details and go to our corners and talk about this and talk about that and come together and hopefully resolve this. Now look, if we give it a good faith effort on July 10th and just can't resolve it, well, we go to trial on July 29th. And it's a different attitude, I think, than if we don't participate in the settlement conference.
If the key thing, as far as I'm concerned, is the fact that under this proposal that we're going to make back to them, there are things in this for the parish that aren't going to exist if the thing just goes forward without a settlement and they start building pursuant to the approvals that they have. The parish will not have a sunset provision on the agreement. The parish will not have the procedures in place to have the development reviewed every year. The parish will not have any control over what this agreement does is that it says that the development code that exists on the day that the proposed development agreement is signed is the one that applies to the entire development. So that gives you something because you know what development code applies to it.
I think the council has pretty much had all their questions answered, I think. Did you have another one, Mr. Mangus?
I didn't see Mr. Harris' claim in here because we had mentioned
it's covered in the ordinance under which the development agreement is created.
Open agreement by Livingston Parish.
There's I don't know if I quoted all the provisions in it, but there's a provision in that ordinance that says that the person who enters into the development agreement with the parish must have title to the property.
They warrant that they have title, which brings Mr. Harris's issue to the forefront. If they don't have title, they warrant they have title. They don't have title, and he proves that it's really him and his people in Texas that have title to the property.
Just
the development agreement fails.
You hit reset.
Yeah, that's not in number 11, though. I don't see it.
It's not in the list because it's not necessary. It's in the statute, and it's crystal clear in the statute that the person who enters into the development agreement with the parish must have title to the property. And if you want to put it in there, we can certainly do it, but it's not.
We
clear
told
in the statute.
gentleman we would do that.
Okay.
Does that satisfy your question there, Mr. Mangus?
Yes.
I got
All right.
one more.
One more, Ms. Sanford.
If it only takes $4,000 for them to pay their fees and get started, then why haven't they done that? What is the sticking point?
I suggested to you.
Hold on. I know exactly what the sticking point is, and there are several of them, and I've tried to kill as many of them as I could in this agreement. The first thing is that they have achieved compliance with the statutory density requirement that the parish has by having green space. They've got designated green space. Everyone strongly suspects that at some point in time they will come back and try to develop the green space and to create additional lots, thereby actually making their density more than the amount in the parish ordinance. Maybe the politics gets right for them to do that, but that's one of the things that we were trying to eliminate. They do not presently have a floodplain permit to develop the floodplain. And what this does is make sure they can't develop the floodplain.
I think our question was, why are they not starting right now?
They aren't starting.
They're not starting right now.
I think that's what your question was, right?
They want the settlement to wrap all this up. I said this earlier. They want the settlement to wrap all this up and foreclose everything and have the federal judge's blessing once and for all.
So
because
this
all the
can't
procedures have been followed.
And so, Randy,
it won't be subject to any attack.
There is concern on their part that the parish is continually amending the development code.
This would stop
and this
that.
would freeze the development
Right.
code
Did you have
at
another
a
question,
point in
Ms.
time.
well, I just want to say, on the agenda was to send Randy DeLatte to negotiate this deal. He's the parish president, and he issued the stop work order.
He's going to be in attendance at the July 10 meeting.
He knows the full history of all of it.
Okay? He's going to be in attendance.
I think part of the
Real quick, Mr. Coach, you had a quick question?
Yes, and this is from Mr. Cassio. We're talking about taking a vote on this. However, the agenda on number 5 says discussion of appointees of settlement. It says nothing about taking a vote on this issue. So I'd like to have your legal opinion on that.
I wasn't planning on taking a vote. I mean, I just wanted to
I
get
haven't heard anybody call for a vote. Y'all were just discussing
Yeah, I
the
wasn't
appointees on the
planning on
panel.
taking
Okay, my misunderstanding.
Yeah.
I was taking it at the last meeting.
I mean, we got, I've already authorized me, but I mean, we got.
I thought we had spoken about giving authority to someone else or something like that. That would require a vote.
Well,
Doesn't require a vote.
okay. I mean, but if there's no wish of the council to move forward, then I don't know that there's anything else left for us to talk about on this specific item.
Well, I'm going to just say it again. You appointed me, I'm ready to go. I think it's my responsibility. I put my hand on that thing to make these hard decisions. Miss Aaron, I don't know why you don't want to, but I think it's highly necessary for you to be there because you know this thing more than anybody, all the pieces of it. Yourself was another. If somebody else wants to volunteer, for just us. But I think we need to go. I think it's my responsibility to put my hand on that thing to make these hard decisions. Miss Aaron, I don't know why you don't want to, but I think it's highly necessary for you to be there because you know this thing more than anybody, all the pieces of it. Yourself was another. If somebody else wants to volunteer for just us. But I think we need to go I think it's necessary that we go. And if I go by myself, I just go by myself, because I do not want to get to the 29th. I want this to be done and over with.
Me too.
And I don't want a federal judge sitting there telling me that I got to pay however many, God only knows what number it could be. And it could be a substantial number, even more than what most people are even thinking it possibly could be. I've been down this road before. They have a thing, they have it approved. Unfortunately, it was not approved or denied based on the master plan from jump. If it was denied based on master plan from jump, I think you got a little bit different court battle. But unfortunately, it was not denied based on the master plan. That's our problem.
Are you familiar with the concerned citizens of District 5?
I'm sorry?
Are you familiar, and have you spoken with the concerned citizens of District 5 and the people of District 5?
I'm like,
They've made it very clear they do not really want a settlement. That's what my understanding of it is. And so by entering into this, you're kind of cutting them off and not allowing their due process.
You did hear these two gentlemen
Yes,
sit here
I did.
and say about,
I sure did.
About the federal judge, and that if it goes to court, which is the 29th of this month, right? Yes. So we're going on the 10th, and then 19 days later, that it's going to be not pretty. And they already have everything that they need other than a check for $4,000 to start construction.
Mm-hmm. So that doesn't make any sense.
He just told you for the fourth time a while ago that the people want it wrapped up and done finally and blessed by the federal judge. I'm not referring to the District 5 citizens, sir. I'm referring to the case.
All right, let's see.
I'm referring to the case that is in front of us,
yes,
that we're having to deal with right now.
I guess
this is going to, if we do not do this, it's on the record, this is going to cost us a ridiculous amount of money, a lot more than that tourism thing is.
Are you sure? You're positive?
I guess.
I'm going by what these two attorneys right here telling us.
Right.
Well, we've currently, I'm just trying to keep it moving forward and keep from repeating ourselves. I know Ms. Sandifer said she's not going to attend and don't want to be a part of that committee, and since it's her district, and I really don't want to be the one speaking for all 9 districts of this parish to put that all on one. I don't know that we should put all that on 3 council members, much less 1. So if y'all would like to, I don't know what your pleasure is, but if we're not going to authorize, I think maybe a motion to just to get rid of that committee for now, or have me not appoint anybody and let it die like that. But I'm asking the council for some kind of direction, because otherwise I'll just say that the council, that I'm not, unless y'all give me some direction, I'm not going to appoint. I'm going to remove just Mr. Goff, since I'm volunteering myself and Ms. Sanders getting off. Then, unless there's some other volunteers, I'm just going to say we don't have. There's nobody appointed to the committee. So.
You go, Ricky.
One second, Mr. Harris.
So let me ask these gentlemen one quick question in reference to your statement. So either you appoint me or whatever, but nobody's appointed. It's not on the agenda for us to give anybody the authority or give you the authority to even go to the settlement agreement. So we just bypass that. Thank you, Judge. And we show up on the 29th and say, hope for the best. That's what we're talking about here.
Mr. Delight.
Is that what I understand?
We will try the case. Remember that authority to do this development is not on the table, because the depositions have established they've got an approved plat and they've got approved construction plans. So no matter what happens in the case that's before the court, it will in no way stop the development from starting, progressing, and everything else. That's not on the agenda. We would be having a different discussion if there was some process that could occur in the case by which we might win and stop the development and get what everybody wants.
Can you pause right there? And I want you to repeat and I want everyone to listen, repeat the 3 things that this federal judge can assign penalties to this council and this parish.
Procedural
based
due
on.
process, substantive due process, and equal protection. Those are the 3 constitutional provisions that are in play here. Now, I'm not telling you that it's a slam dunk on any of the 3 of those, but the depositions lend themselves to some information that lawyer can use. Now, we've gotten way over the top here and talked about a lot of stuff that's trial strategy and everything else. The bottom line is this: either you want us to have authority to go settle the case on the 10th, or you don't. And I think Mr. Goff's willing to go as your representative to do that. If you disband the committee, I don't know what effect that has, but I think Mr. Goff's willing to go and be the voice of reason and report back to you guys during that process, and let's see if we can get it resolved. It's worth a try.
And I would be fine with Mr. Goff going. I just don't know that giving him the authority to speak for the whole 9 councils would be my. And if that would be a desire of the council to offer him to go and listen and come back to the council and tell us what was said.
We don't have that privilege. We don't have that privilege. You see, we're going to go there on the 10th, and it's either going to be resolved or not.
Okay.
On the 10th. I just wanted you to understand the process.
There is a way to do that, which I have put in this agreement. That's the draft agreement that's in front of you. It's not in the one that Ascension Properties drafted, but it is in the one that I have drafted. As I pointed out a while ago, the procedure that I have set out in this one is going to come back to the council for approval of the pieces of it at least twice, and it's going to come to the Planning and Zoning Commission.
No matter if we go to the trial or not, or the hearing or not.
No, that's assuming we get a settlement.
Assuming we
get a settlement, it's got to come back for y'all's blessing.
If we do a settlement like the one that I have drafted here,
then it would still come back in pieces.
It would come back to the council at least twice, and it will come to the Planning and Zoning Commission at least once to implement this settlement.
And if we don't get a settlement, it's going to go to Judge Dick, and she's going to make all the decisions for everyone, including the 5th District folks in the back. She's going to make all the decisions for everyone. And she's going to craft something that she thinks is appropriate. And that's where we are.
Okay.
Sorry, Mr. Ernie, but I don't...
John Mangus.
I don't think...
Make it quick.
I don't see that in these...
Don't see which?
What you just said in the 12 statements. It says that the preliminary plat as of September 18th, 2023 has to be accepted. It doesn't say, in fact, further here it says, construction plans were reviewed for compliance with the applicable construction regulations. It doesn't say anything about any future regulations or ordinances. So it doesn't mention Mr. Shaver's emergency evacuation because that wasn't in place at the time.
What the agreement says is that the development code that applies under the development agreement is going to be the one that's in effect on the date that the proposed development agreement is signed. That's a date in the future. It has not happened yet.
Okay, it doesn't, it doesn't say that. It says September 18th, 2023. That's a date.
That's the plat. That's the plat. The basis for the development agreement will be the plat that's already approved with the one modification, which is the size of the 42-foot lots. That's the first thing it says.
Right.
But you also have in there that the development code requirements that are going to apply under the development agreement are going to be those that are in effect on the date that the proposed development agreement is signed. That proposed development agreement has not been signed yet.
So is that number 3?
Hold on.
What page are you on, Mr. Mangus?
I know where
Been adopted, it'll be after that.
Thank you, page 11. Is that number 3?
Yes. The construction regulations applicable to the Deer Run development will be those in effect as of the date of the signing of the proposed development agreement. That is an event that hasn't happened yet
But number one seems in opposition to that. The basis for the development agreement would be the preliminary plat approved.
That's what it looks like. Number three is procedural.
Okay. Also, the green space, to calculate density, it doesn't say that the green space can be wetlands.
The green space requirement and whether it can be wetlands is covered by the existing ordinance. My appreciation is that it can be some kinds of wetlands, and there are other kinds of wetlands that it cannot.
That's traditionally what they do.
Certain kinds of wetlands that are subject to regulation under the floodplain ordinance. And one of the other provisions I have in this is that they will not develop anything that's subject to the floodplain ordinance.
All right.
That's not in there now.
But it's
not in, that's in our settlement wishes.
right. That's in our settlement wishes. It's not. They currently do not have a floodplain permit. They could file for and ask for a floodplain permit. It would have to be reviewed under the criteria that other people who have applied for floodplain permits have been reviewed by. In other words, there would not be any ability to treat them differently from the way other people have been treated. And what I've tried to do is be totally consistent with that.
I had one other quick question, Mr. Aaron, and I were kind of talking back and forth, sort of like, so Mr. Randy DeLatte is listed on there. So is there any reason why Randy could not be our representative and have that power or authority? Is it because he's in administration and we in legislative body?
That was the consideration, that it would be, Randy's going to be there on the 10th. We wanted some legislative representatives to make sure that everything was solid and that you're a cross-section of you guys, so that we could get your input on the day of reckoning and make it part of the resolution, or point out things that you say are deal breakers and you can't have a settlement. Either way, the federal magistrate judge is expecting us to participate. Either way.
But can Mr. DeLatte carry out what we are saying?
That's what y'all put on the agenda at the last meeting.
Mr. DeLatte could go as the representative for the parish. You could appoint him as the representative for the parish to go. He's planning on going anyway and actually bringing a number of members of his technical staff. If
it desires the council, I'll be glad to just say, Mr. Ricky, that we'll just pull all three members and say Mr. DeLatte is our representative, if y'all want to do that.
Can you abolish the committee as a chair and do that?
Well, I would think that committee will be made up of him only. So, I mean, if we remove you.
But it's not a council committee.
What does it say on the, what did we say when we came back?
Yeah, I think.
You said you appointed the three-member committee to.
What's that?
Y'all called it a panel. You didn't call it a
We didn't call it a committee. It was panel. That's what it was.
Did we say, may I ask Ms.
Sure, I don't think we said it had to be required.
Did we say it had to be council members on that panel?
No, I think we were pretty sure. But if y'all good with that, we'll just say Mr. Randy is the appointment for that. And
A question for Mr. Cassio.
Is it legal?
Excuse me. It's coming.
Yeah.
It's coming.
Is it legal? That's what
Okay, Mr. Cassio, is it legal for us as a council to give that authority to one person to negotiate that settlement?
Yeah, typically, the parish council can pass a resolution authorizing the parish president to sign documents and enter into agreements. That wasn't what was on the agenda tonight. So if you didn't do that at the last meeting, you're not going to do it tonight.
Okay. So maybe that option's off the table then.
I don't think that we should give our council authority to the parish president. He needs to go as parish president.
Okay, well then.
I agree with you 100%.
So maybe then we just take no action tonight, and I'll just say that the committee's dissolved.
The panel.
So the panel will be dissolved, and then good luck. I'll get to you 1 second, Mr. Harris. If you would, I got someone who wants to come say something real quick, and so we got another item, two more items coming up on the agenda. Mr. Harris, you want to come up and?
had an open question that didn't get answered.
Well, by all means.
Mr. Goff asked what's changed.
Pardon?
Mr. Goff, I believe, asked what's changed since we were here the other night. Was that your question, sir?
Early on it was, yes, sir.
Yeah, and nobody's answered that for you, have they?
Sort of.
What answer did you hear?
The fact that we don't want to go and represent the parish and try to settle
No
this thing.
material change, just somebody woke up one morning and changed their mind.
Go ahead, Mr. Harris.
I just wanted to produce you with the material change that has changed.
Yes, sir.
Today, there's been a notice of lease pendants filed in the courthouse, in the conveyance records and the mortgage records, stating for everyone and giving public notice to anybody that the title of the property is in dispute. Any agreement entered into after this is completely 100% subject to the resolution of the court. Any contract that goes into entrance onto the property, and it ends up being damages to the party who is the eventual prevailing party in the court, it has to do with multiplication of damages. $100,000 in damage becomes $300,000 in damage because you were in bad faith. It was in the courthouse. You were aware there was a question with title. You entered into an agreement. That would include your settlement agreement. So that is a material change as of today. Now, just a couple other things that were asked about. They referred to a while ago of Livingston Holdings or Ascension Properties or whoever being in possession of the property and complete access. I want it remembered that there is a gate that gives access to that property. There's 2 locks on that gate. One of them belongs to me, and I have full access as well. So I want that to be clear. The other thing, y'all seem, and I'll just open the question. You don't have to throw tomatoes at me. Some of y'all seem to have questions about whether or not you want to settle. Is that true or not true? Is everybody on board, let's settle?
Well, let me just say, it looks like we're taking no action, which means we're not going to go to the settlement conference, which I think is exactly what you want.
Okay.
So I mean, how about we just leave it there?
Okay. Well, I thought you had said take no action tonight.
That's right.
Well, so are they going to attend the settlement conference?
Well, no one from this council is going to go.
Mr. May I ask a question?
Mr.
Harris, which court? You said that you filed this in a court. Which?
Yeah, it has to be in Livingston Parish Courthouse. It's in our conveyance record.
21st Judicial District?
Well, that's technically the 21st Judicial District, but it has to be in the courthouse where the land is situated, for the parish where the land is situated. So it's in the conveyance records because it makes sense. The mortgage records because that's what the statute requires. And another thing is, you all said that if they pay the $4,000, whether it's on the 29th or after the 10th or whatever, they then have to go to another pre-construction meeting. Did I understand that to be said?
We didn't say they had to
I
pay
didn't say
$4,000. The gentleman said they had to pay $4,000.
Yeah, I think there was a pre-construction meeting that was.
To start the development process, they have to pay the $4,000, I think it's $300 and something fees, and attend a pre-construction meeting. At the pre-construction meeting, there is a document that doesn't cost the developer anything that is issued called a development permit. So the development permit would be issued, and that would be their authority to go turn dirt over on the property.
Mr. Harris, Mr. Irvin had mentioned that the Ascension Properties has been paying taxes on it. What's your stat? Are you paying taxes on it?
Ascension Properties haven't been paying taxes on it. Livingston Holdings has been paying taxes.
Or Livingston Holdings?
Livingston Holdings has been paying taxes. No, I haven't paid taxes. I didn't own it till March.
So who's owned it from March back?
That's what we're arguing about.
So have the people that from March back, have they paid property taxes on it?
No, absolutely not. They haven't had any notice that they owe taxes.
Okay.
So the next question, at the pre-construction meeting, your ordinances require that the owners be present. With the lease pendants in the courthouse, you can't declare which owners are supposed to be at any pre-construction meeting.
Does that mean you're going to be there?
That means I'm supposed to be there.
I was just...
No, that means I'm supposed to be there.
Okay.
The other thing is, y'all seem to be just up in the air, and I don't understand this part in the judge's order. And I was present. We weren't present. It was a telephone conference, but I was a party to the telephone conference when this was all being discussed. And it says the parties also agreed that they are amenable to a settlement conference. Now, if y'all had not given anybody your authority to go into a settlement conference, who had contacted each of y'all and decided you were amenable to a settlement conference? You seem to be in disarray.
I don't understand your question.
Okay. When we had a conference with the judge, your counsel stated that y'all were amenable to a settlement conference. Who had told him prior to that conference that y'all were amenable to a settlement conference?
I can't answer that. Maybe Mr. Irving standing up could answer that?
That's legalese. It goes into every one of those provisions. The judge commonly asks this would be with the Article 3 judge, not with the magistrate, if there's any possibility of settling this case. You don't want to aggravate an Article 3 judge by saying, no, judge, this is a go to the mat, we're going to fight to the death. You don't want to say that, so you always say, yes, judge, we will, and Randy was in on this, we would certainly talk about settlement. That's every client I've ever had said that, and most of the time they mean it and they do it, and sometimes it works. That's all that process is.
Did that answer your question, Mr. Harris? It was, I guess, Mr. DeLatin and the attorney.
Boilerplate language then.
Yeah, it's kind of standard. That answer that question?
Sure, we're good. Just that there was another development agreement that Mr. Irvin just spoke to that would be issued after any pre-construction. And the lease pendants means anything done on that property. After that agreement, now that the lease pendants is in the courthouse records, opens up to the eventual actual owner.
Well, you've got that on public record now. So.
Absolutely, so I was letting y'all know too.
Thank you so much.
Thank you.
All right, let's go ahead and shut it down, but I think there's one comment you got. If you can make it quick, if you, I mean, because we kind of know what we're going to do here, and that's enough.
Chad Idrolamo, 9796 Vincent Trace, Dennis Springs, Louisiana. So just want to say that the last election when y'all were all voted in, just speaking to people in social media, y'all were voted in because y'all were on our side. Y'all wanted to stop this development, slow it down. Ever since the election went through, I mean, not with Deer Run, but the traffic has just progressively got worse. Crime's getting worse. We need to stop this, and I hope y'all listen to the citizens that elected y'all. We need to slow down, and I want y'all to do what's right and what y'all were elected to do by us.
Yes.
Because that's what,
I think that's what we're doing.
I think anybody would say that's why y'all were elected.
That's what we're here to
because we
do.
trusted y'all. So I hope y'all do the right thing to protect us and our families and y'all's families. Thank you.
Mr. DeGirolamo, I think this is the perfect moment to go on record and say that I can speak for myself, and I think others would agree, are absolutely committed to protecting the health, welfare, and safety of the people of Livingston Parish and all districts that we serve in.
Correct. I mean, that's when we started. That's why we started this against Deer Run, to protect the safety, welfare of all our citizens.
Right.
And I hope y'all do that. I mean, it's every day traffic gets worse. All these neighborhoods that are popping up before y'all,
Sure.
and it's just going to progressively get worse, and we need the infrastructure, the schools. So I hope y'all do what y'all were voted in to do.
All right,
Thank y'all.
Thank you so much. All right, if there's any action from the council, otherwise we're going to move on to the next item. So in 3, 2, 1. All right. Next item is this item 6, consideration of engaging Danny P. Garrett III, attorney at law, LLC, as special counsel under Section 4-02 of the Charter to provide legal services to the council and members thereof. I believe this was placed on the agenda by Mr. Joe Erdy and Mr. Dean Coates. Is that correct? So I'm going to turn it over to y'all, and you got it.
I'd like to speak first. Okay, Dean? All right. Yeah, first of all, I want to thank the public for coming out tonight to hear this, because this is very important. And I just want to say, since I've been here, I've heard a lot of talk about we don't have strong representation by the council, not from numerous council people, not every single one, but from numerous ones. So with that being said, we talking about trying to find better representation, and I took that to heart, and I got fortunate enough to meet an attorney from Baton Rouge, and I have spoke with him, and also I think a few other councilmen may have spoke to him. And just in listening to this man speak and knowing his knowledge, I think he's more than capable of leading Livingston Parish into the future for not just the elderly or older people, but for our kids and grandkids. And I want to repeat that. He's more than capable of leading Livingston Parish into the future for us and the kids. We're all here tonight to meet this man and listen to his qualifications, and upon that, answer any and all questions you may have. And I don't even know if this is possible, but if we can, we could vote on something tonight pertaining to hiring him and/or changing the meeting times. We can discuss that as we move along. But with me saying all that, I'd like for y'all to meet Mr. Danny P. Garrett III. Would you come up, Danny, please, and speak and give us your itinerary?
Mr. Coates, did you want to say something first, or?
I'll let Mr.
Okay, go ahead.
Yeah. Proceed.
Chairman, Mr. Erdy, members of the council, my name is Danny Garrett. I'm an attorney in Baton Rouge. I actually met Mr. Erdy because he contacted me about representing him in the litigation that he was involved in. From that, he asked, and a couple other members of the council asked if you know, what I did. A little bit about myself. Graduate of LSU Law School. Was in actually a rented space from Steve Irving, or I worked for a lawyer renting space from Steve Irving, so he's known me before I had gray hair. But early on in my career, I began working for the Louisiana Municipal Association. I did that for about 5 years, representing municipal governments. From there, I went to the legislature. I was the attorney for the House and Governmental Affairs Committee, which handles public records, open meetings, ethics, elections. From there, I was recruited over to the Police Jury Association, where ultimately I served as general counsel for about a decade. And in 2011, I've been in solo practice, with the exception of a couple of years where I worked for the Butler Snow Law Firm in their Baton Rouge office. But the big law firm thing just didn't really suit me. We parted friends, but I just prefer being a sole practitioner. My practice, a significant portion of my practice is representing parish governments. I am the parish attorney in West Feliciana Parish. I am one of the attorneys in Point Capee Parish. I actually helped draft their new home rule charter that they are utilizing right now. I am currently the attorney for the Plaquemines Parish Council down in Plaquemines Parish, Louisiana. I also do regularly work for West Baton Rouge Parish, Tensas Parish, and Madison Parish. I also represent some school boards, and in my lobbying side of my practice, I actually represent the Louisiana School Boards Association and a library board and a couple of other local government interests. I've been doing local government for basically my whole legal career. So when the question was posed to me, you know, I was asked to look at y'all's charter. Your charter retains the district attorney's office as the statutory legal advisor, that's the base of parish government. The DA is the statutory legal advisor. And even in the police juries that I represent, they have a process where I get appointed as special counsel to do the work that the DA would prefer be handled by someone else. In the other parishes I worked in West Feliciana, they opted to create a parish attorney's position, which I served through contract. In Point Capee and in the other parishes, I'm just special counsel. I don't handle their day-to-day stuff. I handle the stuff that they ask me to. One of the things that was discussed with me was particularly my work with Plaquemines Parish. Plaquemines Parish is somewhat unique in the sense that their council actually in their charter has the ability to hire their own lawyer along with a parish attorney. And the parish, and I've been working there since about 2016. Basically, I work for the council. I attend the council meetings. I assist the council members with everything from parliamentary procedure to drafting ordinances to ethics issues.
You say their charter allows for the council to have?
Yeah, they are very unique in the sense that them and Orleans are the only ones, and I've actually litigated this for them. They're actually a juridical person. They actually can sue and be sued, which is very unique for a legislative branch of a parish government. A lot of people know the Lafayette case where you can't do that, but they actually have a special attorney, special provision. Now, the other parishes don't have the council. I'm not employed by the council. I'm employed by the parish. That's more akin to what y'all have. Y'all have a provision where the DA is a statutory legal advisor. It's my appreciation that historically that's been handled by the DA, essentially farming that to a private law firm, in this case the Moody Law Firm. And y'all do have a provision that allows for the council to engage special counsel. And it's normally a situation where you're not asking someone to come in and be the parish attorney. You're coming in and asking someone to handle a sort of a narrow area of law. In fact, I was able to locate, I know there was some question, Attorney General's Opinion 12-0071 was issued and actually on your charter specifically, and specifically does provide that the AG states, reading Section 402, it is in its entirety leads to the conclusion that while the district attorney represents the parish in all general legal matters and proceeding, the council is authorized to engage special legal counsel to represent the parish, provided all the conditions described above and set forth in Section 402B are met. Further, there is nothing which prevents the council from engaging separate legal counsel in a case in which it's currently handled by the district attorney. What was provided to me, because I understood the Moody Law Firm handled that, and I've known who Mr. Moody was. I think I met him the first time the other day, but I think I've talked to him before, just given my background, was that back in May, there was somewhat of a change to the engagement agreement between the Moody Law Firm and the district attorney's office with regard to what the Moody Law Firm would provide. And two of the, I guess, the significant changes were provision that they were lowering the amount of money, and for that, the Moody Law Firm would have to provide some less services. And one of the items was not being required to attend your council meetings, and also not being required to respond to specific questions by members of the council. So I was asked by a couple of members of the council, would I be willing to fill that role? The first thing I looked at was a conflict that I have, and that is, I mentioned the Plaquemines Parish Council. They meet on the second and fourth Thursday of every month, same as y'all. And they've been a client since 2016, and it really wouldn't be professional of me to say I could do you when I'm doing them. Because first of all, Plaquemines Parish is a little bit further drive. It pretty much takes a whole day for me to go down there and back. But so what I told a couple of council members is the only way I would be able to assist you into sort of filling that gap into what was being reduced in the new engagement letter with the Moody Law Firm is if y'all could move your meetings to a different date when I have availability. And I kind of gave them the dates because that's what I do. I attend these meetings. So the second and fourth Tuesday of the month, I'm in New Roads. The second Monday of the month, I'm in St. Francisville. The second and fourth Thursday of the month, I'm in Plaquemines Parish, either in Pointe-a-la-Hache or Bellchase. There was an expression to me that there may be an interest in moving your regular meetings to the first and third Thursday. And if they did that would open this availability up. What I did is, at the request of a couple of council members, I did submit a proposed letter of engagement, which essentially provides that what I would be engaged to do would be to attend your council meetings and to provide that direct legal advice to members of the council for matters pertaining to them serving as members of the council. It had to have a proviso in it that the only way it could work is if y'all were willing to move your meetings to the first and third Thursday, simply because I can't walk away from that long-term client. So that's kind of it in a nutshell. Like I said, I just sort of fell into working for local governments. I sort of fell into working for the LMA, and then it just kind of stuck. And I've had the opportunity to represent a lot of local elected officials, and I've kind of decided I like doing it. Y'all don't do this for the money, certainly. You don't do it for the power. You do it for public service. And so I'm sort of used to representing those people. Also, when I was on staff at the House of Representatives, working for 7 or 9 members on a council is a whole lot easier than working for 105 House members, because that's what you do when you're on the legislature. But so I'd be more than happy to answer any questions. Like I said, I have priced the letter of engagement to essentially replacing that item, essentially replacing that money. So
Mr. Coates had a question, I believe.
Go ahead.
Yes, sir, Mr. Garrett, thank you for that synopsis there. I do have a couple questions for you, because I don't want to say anything negative about Mr. Moody or their representation. All I'm wanting to do is clarify a couple of issues. And as I look on his engagement letter, number 1 through 3, there's a lot of notations I have on here, but all of those require responding to limited phone calls from the parish administration and the council clerks. There's no responding to any council members on any particular items. Would you be willing in your engagement letter to do that? I think that you said that you would, but I just want to make sure that's on the record.
And in my engagement letter, it specifically provide assistance, advice, and guidance to any member of the council on a matter related to the holding of offices or member of the council, including but not limited to the Code of Governmental Ethics, Public Records Law, and the Livingston Parish Home Rule Charter. Provide assistance and guidance in drafting of ordinances, resolutions, and other items for consideration by the council as requested by the council or by any individual member thereof. I tried to essentially style what I was offering to do for you to sort of fill the gap in what the Moody Law Firm was withdrawing. And again, I don't have anything negative to say about the Moody Law Firm. Right. Chris and I, we tried that hearing together the other day. I know that they've been a long time counsel for Livingston Parish government. I was not aware of the change in their engagement until it was provided to me, and that's sort of what kind of got it started. Is there some way you can come and fill that void? And that's what I was asked to offer to do.
If I may just butt in for just a second, it does say parish administration, council clerks, or council representative. Now, I can speak for myself here. Not a single time.
What are you reading from?
This list of what we do for you guys. Okay. Responding to unlimited phone calls, text messages, and emails, quite frankly, from anybody. You each have my personal cell phone number. And not once, whether you call me at 7 o'clock in the morning, when I'm getting my kids ready for school, or 8 o'clock at night when I'm tucking them in bed, have I ever denied any council member here a phone call, text message, email. And if it is, it's a text message, hey, I'm putting my kid to bed, I'm going to call you right back. And then I call you right back. I just want to make that very clear. I have not stopped rendering services to anybody for any reason, nor do I charge anything for those phone calls.
And I agree, Mr. Caskey. I think under the prior agreement, that's exactly what y'all did.
That's what we still do.
And that's what I've been told by council members. I think what was drawn to my attention is the line in the new engagement letter that says we will respond to legal questions as requested by the administration or by resolution of the council, but not at the direction of single council person. So I think that would be somewhat of a change. And again, I didn't have anything to do with drafting the new engagement letter. I do think it is from what I appreciate, it is somewhat of a departure from the way it's been handled, because, like I said, you have his cell phone number.
Can you give me?
And I'm sure Mr. Cassio has always responded, and I've heard nothing but positive about that.
Sir, can you give me the date on what you're reading from? And Dean, you do the same?
It's a letter dated May 14, 2024. It's entitled Engagement Letter. It's on the letterhead of the Moody Law Firm.
Because mine, same thing. It says May 14, 2024, and it's signed by the parish president.
Yeah.
And it says representative. Yours doesn't say representative?
And
it does say council representative, but what is the definition of the council representative?
I don't know, but it was weird that you just left that part out.
Mr. Cassio, do you know what that definition refers to?
I think it shows about what we do. Name a time where I've ever denied a phone call from any of you, or an email or a text, weekend, holiday, night, or morning. Never once. I don't mind doing it. I've been a public servant since I started working.
I don't think anyone's accusing anyone of that at this time. What we're just talking about is what the contract changed to reflect this. You know,
I mean, I'm sure.
If anything, a representative for the parish council needs to be accepting of parish council members who want to call them, and this contract says something different. And when we found that out, it was a cause for concern.
I'll be honest with you, I think this was more of a concern on the administrative end, that they wanted to be informed of what was happening and they wanted to know what was going on. It had nothing to do with us wanting to limit our contact with you guys.
Sure. Okay, Mr. Coates, you have any more questions, or?
No, I think some other questions might
real
be.
quick, I'll get to you, Mr. Taylor, Shavers. Let's go. Let's
I
go.
just have one quick question.
Sure, go ahead.
So I'm just going to read from here. This is Moody's engagement letter. The fee will be paid directly from the district attorney's office out of the general budget. The parish pays to fund your office. For us to provide this service for the reduced fee, we will be relieved of the requirement having an attorney attend council meetings or planning and zoning commission meetings unless compensated at the discounted rate. So if we change the meeting days, you're willing to come to our council meetings for that amount?
For the flat fee would include me attending your council meetings as well as responding to any individual council members. Similarly, I think to what y'all historically had through the Moody Law Firm, and I don't know internally at the Moody Law Firm how this is being handled, but like I said, what was related to me was that there was this apparent change in what the Moody Law Firm was going to do in exchange for the reduced amount that they were being paid.
And you would also, and you and I talked on the phone, but again, I just want to, on public record, for this same engagement letter, which I'm sure you would revise if we engaged you, you would come to the planning commission meetings the first Tuesday if that date worked for you. You'd be willing to do that.
First Tuesday of the month. I don't currently have a conflict on the first Tuesday of the month. Like I said, I have the second and fourth Tuesday, but second Tuesday is available.
All right, Ms. Sandifer.
I just want to point out, maybe I misunderstood, Mr. Garrett's contract is $2,000 per month, not the $6,000 that you read in Moody's contract. Did I hear that wrong?
Are you looking at me?
No, that's correct.
Yeah. His is $2,000 per month, and his AG rate is, let me find it. It's
$225?
It's $220 or $225?
$225.
But he also, and this is very important to me because it's something that I have been asking for quite some time, is an itemized statement of the retainer. In the past, we paid $8,000 a month for a retainer fee, and I still do not have those invoices. And he's willing to provide the invoices as well.
Well, and I'll tell you, I have a similar arrangement with Point Capee, where for a flat fee, I attend their meetings and I answer general questions. If they engage me to do litigation, then I bill by the hour, and they get a regular, traditional, hourly billing sheet. I don't do a billing sheet for them for the 2,000. It's just they call me as much as they want to use me. Just because you're not billing by the hour, so I'm not keeping the 0.3 hours here, 0.5 hours here.
And that's what we've tried to explain, that on a retainer amount, no law firm in the country is going to give you a minute by minute, hour by hour itemized bill for that. Nobody keeps track of it because it's a flat fee. Right. In addition to that, I would like to point out that the $6,000 that Moody Law Firm comes from the DA's office, which is already being funded by the parish government. Under this contract, it would be an additional $2,000 a month in addition to what's already being paid to the DA's office.
Well, we're not trying to take you out. It's up to reading the contract. You can dissolve it within 30 days or keep it. And so y'all, if Mr. Delatte wants to renegotiate it, that's fine.
I do
we
think
don't
there's
have
a bigger
problem with
picture
that.
item, though, that we're kind of glossing over. I sent out a memo earlier today that the Louisiana Supreme Court's already looked at something like this. St. Tammany's Home Rule Charter has the exact same language ours does, and they said you can't do this.
But I think what Mr. Dan is doing is making up the shortfall where you guys put in your engagement letter the obligation of coming to the council meetings. That's where he comes in and says, look, if they're not willing to do that, I'll do it. I think that's, I'm not even talking about the money here. I'm just talking about legal representation. You or Chris Moody have no obligation right now as it stands to come to our council meetings as our legal representation.
But we do.
For the past 2 meetings, you weren't here.
No, the last week I was out of town at a conference for the district attorney's office, so I wasn't here. But anytime I'm available and anytime I am asked to come, I show up, and I don't mind it. That's what I'm here to do.
But when y'all show up, it's at $175 an hour, correct?
Yeah, and so is that more or less than $2,000 a month in addition to what you're already paying?
Well, I think that I don't know how y'all's fee structure is set up, but if a contract was negotiated between the parish president and the Moody Law Firm, then it would appear that whatever we're paying to the district attorney's office to in turn pay Moody Law Firm would be in excess of what we would normally pay.
I don't follow because I don't do the bookkeeping.
Right.
I will say I did inquire to Parish President Delat, and he was perfectly fine with this and said, yes, the money is there, and
it
it's
may
okay.
be, I don't know. My appreciation of what the Louisiana Supreme Court ruled is that you can't do this because Mr. Garrity's obviously extremely qualified, and I'm not saying anything about that. And if this is what the parish council wants to do, hey, do it. But if you're going to do it, my job is to make sure whatever you are doing, you do correctly. And it's my appreciation of the law that if this is what the parish council wants to do, the parish council has to amend the home rule charter.
I want to say one more thing. We do have a letter from Mr. Moody in writing saying that, correct me if I'm wrong, that he would not be back to our meetings.
I don't know anything about that.
He sent a letter out on the date that it was just before this contract was signed. It was at our May 9th meeting, and this contract was signed on May 15th or May 14th. And he was, didn't we have an executive session that night?
I don't know.
Yeah, we had an executive session that night, and he did, and we can pull the letter, but I'm pretty sure he said he would not be back.
I can't speak on behalf of Mr. Moody. All I can tell you is when you guys have asked me to be here, I'm here. When you ask me to answer the phone and give you a call, I do that too.
I think Mr. Mangus had, let's give him the floor.
Okay.
Unless you have something.
No, that's
okay,
fine.
Mr. Mangus.
I will concur that, yes, Mr. Cascio, you have always taken my phone call at least. But from the way I understand it as the financial chair is we were paying $8,000. It got reduced to $6,000. Certain services are cut. If Mr. Garrett wants, a letter of engagement of $2,000, that's still back to the $8,000. So we're not incurring any more. The main issue is if it's legal and if we have to amend the charter. But I mean, as far as it's not spending more money of the people's money.
Mr. Goff, did you have something?
Yeah, I appreciate you coming, and I met you after the thing, and the court case with the tourism thing, unfortunately, didn't go our way, but so it's correct, it's $175. Our meetings average probably 3 hours, twice a month. So that's a fee that we take in, and I'm gonna say 3 hours. Sometimes they're less than that. Probably averages 2.5. So that being said, you're looking at $350. You're looking at $800, $780. So I really need to understand exactly what Mr. Cascio, Mr. Moody Law Firm, where their shortfalls are in being responsive to us. I think everybody here agrees that Mr. Cascio has been responsive. I don't think anybody's going to dispute that. He's been at the council meetings. We're willing to pay that little fee. So I guess what I'm really trying to iron out here is really where is the shortfalls that's in the contract based on where it's at now versus what this gentleman here says he's going to feel. Not to mention we got looking at trying to change the council meetings, which is going to be a conflict with the televised part of it, as I understand. I'm not 100% sure about that. So the only way we can hire this guy is under special legal counsel. So you're hiring this attorney for a special purpose, and that's what it is. And I don't see the real void. That's just what I'm saying. May not like what he says sometimes, etc. But and I know the bills and all that stuff. or an issue, but they're at our council meetings for $175 an hour. And it says here very clearly, responding to unlimited phone calls from the parish administration and the council clerk or council representatives. And I mean, I feel that's us. I feel if anybody represents this council, we represent this council as a whole, individually and collectively. So I mean, I read that and I haven't seen anything that tells me otherwise, because when I pick up the phone, you know, I've gotten response from Mr. Cascio, even information in the folder. Anyway, so I still need a little bit of clarification where the shortfalls of the contract part is. They're here at the meetings based on $175 an hour. They respond to our calls. Their litigation is $175. This gentleman's litigation is $220, so that's $45 more an hour. So where's the shortfalls that's going to put us to hire another attorney and move our council dates and everything else? I don't understand it.
All right. Is there any more comments from the council? Because we probably have some people in the audience.
I think Dean's looking for his rebuttal.
I didn't mean to cut you off, Rick.
No.
Okay.
Dean's got a
probably have some questions.
No, I believe during litigation, and correct me if I'm wrong, Mr. Cascio, it's $175 and it's $80 for paralegal or something like that. So when you do the math on that, it actually comes up to $255.
All right, hold that thought. You're not going to charge us for paralegals?
I don't have a paralegal.
Okay.
But and just to clarify, Mr. Goff,
I want to make sure. Apples to apples.
If the Cascio law firm is going to continue to come to your meetings and to respond every time y'all pick up the phone and call Ms. Cascio, if he's going to continue to do that, then there is no void. What was portrayed to me was that and I think, and it may just be inartful in the language of the engagement letter, because while it does say council representative, on the second page of the engagement letter, it essentially says, but not individual members of the council. And that may just be semantics, and it may be that y'all just need to designate that any member of the council can contact them. Within that existing $6,000. And so certainly if y'all are going to get the exact same services for $6,000 that you were getting for $8,000, it makes no sense to hire me. Okay? I will first tell you that. Now, with regard to the St. Tammany case, I've dealt with the St. Tammany case in the past. It's a little bit different situation. In that situation, St. Tammany Parish government essentially hired what they effectively called a parish attorney or an executive counsel. When the new district attorney got elected, he went in and said, wait a minute, I don't think y'all have the authority to do that, because they didn't. And if what y'all are proposing to do is to hire me to be general counsel for the parish, he's absolutely right. You do not have the authority to do that under the St. Tammany case. But the St. Tammany case doesn't prohibit you from hiring special counsel if authorized in your charter, and that's essentially what the AG determined in 2012, looking at your charter, not at another charter that's like yours. So I think y'all specifically have the ability to do it. So if the Moody Law Firm is not going to be able to provide the same services that they were, and y'all wanted to engage someone for that narrow purpose, that I think would fall within Section 4.02 of your charter as special counsel. If Moody Law Firm is going to continue to provide the exact same services at a lesser rate, then I'm not a taxpayer in Livingston Parish, but you should do that if it's going to cost you less money, because although they're paid by the DA, I think we all know the money is passed through. Y'all fund the DA funds the Moody Law Firm. So that's, like I said, I was asked to submit this proposal because I think there are some members of the council, when reading the new engagement letter, felt like they were not going to have the ability to call Mr. Cascio whenever they needed, and we're not necessarily going to have legal counsel at each of your council meetings, which I think is critical, particularly of a council of this size and in a parish this size. I mean, Plaquemines is a much smaller parish with much smaller budget, but they still benefit from having someone there to make sure, because again, you are lay elected officials who do this part-time, and you're despite what some have said, there's no way you can be an expert in all of that stuff. It's why you hire somebody who's crazy enough to do that. But certainly if Mr. Cassio is going to continue to provide the exact same services that he was already providing, there would be no reason to pay the extra $2,000. But if the explicit language in the agreement is correct, and that is that they're no longer going to be responding, then that would adjust the numbers. Now, you're right. Just the attending of the council meetings is $700, $800, $900 a month, basically. The other $2,000 would be those phone calls that he would get in the middle of the night. And certainly, if you were billing those at an hourly rate, and I do. I have clients who pay me 100% hourly. And every time I get a call from a council member, they know the clock starts running, but they also know I put their name on the invoice line. So if I spent 0.7 hours doing something, everybody on the council knows. And I've been doing this a long time, so all my bills are public. I don't get to do anything privately. So, like I said, I was just asked to provide this. Like I said, I was representing Mr. Erdy individually. He suggested that they might be this void, and if I can help y'all, that'd be great. If Mr. Cassio is going to continue helping y'all, that's great as well. You're not going to hurt my feelings.
Thank you so much. I know there might be some people in the audience that had something to say, Dean.
Thank you, Mr. Garrett.
Mr. Perilou, I believe, did you want to?
A few words. Won't take long.
Thank you for coming.
Give us your name and
Scott
address.
Perilou, I'm the district attorney for the 21st Judicial District. A lot of things were said. Let me just, there were negotiations done 6 months ago when Mr. DeLatte and the new administration took office about this agreement with Mr. Moody. We were asked to reduce our fee. We did that. The level of services, I would suggest to you, is not any less. And I don't understand, Mr. Coach, you bring up something about returning calls or getting calls, and there is no specific instance, no occasion at all where that's happened. So you just bring it up for the sake of bringing it up to make it look like it's an issue when it's really not. It's just really not. Mr. Erdy, I've known you for years. You come in here and say we need strong representation. I've never heard from you on this issue. You called me many times over the years. I've returned your call. I've never heard from you about this issue. And you're going to bring up in this meeting that you need stronger representation.
Yes, I do.
Okay.
Yes, I do. I think
and maybe following the advice of legal representation would be a good start. So,
well,
with all that being said, all that being said, I know Mr. Garrett, he's a good attorney. I don't know him personally. He's well qualified. I disagree with his analysis of the St. Tammany case, Montgomery versus St. Tammany. It's right on point. It is after that Attorney General's opinion he cited. It is strictly, purely against this charter for these services that he outlines in his engagement letter. It's against your charter to do that. Now, if you want to amend the charter, take the steps to do that about legal representation. You can do that. That's been tried before. It was tried about, Sandy can tell you how long ago was it, 10 years or so. It's been tried before. Doesn't offend me one bit. But
no, I think
it's just a little concerning to just hear accusations with nothing really to back it up.
Well, what I've been here only 6 months, as you know, I've been here 6 months, and I think in talking and speaking for me, and I believe I speak for a few other people, but I'm not going to word it that way. I just want somebody that fights harder for what, in a way that we're not satisfied with. And I've had that conversation with other people. That's it.
What does that mean? Give me an example of what that means.
Well, I don't know if I can discuss it in open court.
You said it.
Well, I don't know if I,
What's that?
I don't know if I'm supposed to discuss things in open court or not. I mean, you say give you an example.
Yeah.
Well, I had a trial just recently. You want to put in layman's terms? Is that okay with you?
Any way you want to do it.
Okay, let's do it that way. And I had Mr. Garrett over there as my attorney. The counsel had Mr. Moody fighting for the counsel. And what I said by better representation earlier, and which means what I'm saying, and that's I saw a man that fought whole lot harder for me than Mr. Moody did for this council. Let's put it, look, I'm not no lawyer like you, nor district attorney.
I know you're not.
So let's just say it the way it is. I watched somebody fight their guts out for me, and a token effort was made the other way. So you asked me what
Turn out for you.
Well, we're still trying to settle it right now. It's not settled yet. So, it's not to win or lose. It's the effort. Okay, I could have won, I could have lost. It wouldn't have made. It's the effort that somebody representing this council puts into it all the time. That's the only way I know how to do it, and try real hard. And I had a man that put all he had into it, and I think there was even a mistake by the newspaper involving that, saying it's over. Well, it ain't over with yet. It is not over with. But I think, quoting Mr. Moody, it's over with. So that shouldn't have been even put in the paper, because we're still fighting the case right now.
Okay.
And that's the best way I know how to explain it. Somebody that's going to give it all he's got all the time. It's not always about returning every phone call. Yeah, you should. You should do that. But it's just about we get an issue over here and there's somebody sitting over there, or we call you, we want 100%, not 72% or whatever. Because that's the only way I know how to do things. And that's my way of living and doing things. So you asked for an example. I didn't know if I should say that or not, but that's how some of us, not just me, but I can't say no more than me, felt about the issue.
Gotcha.
Anything else, Mr. Parrott?
Again,
I would like to say something.
Maybe, Mr. Garrett, you have some. You said you feel like that AG's opinion allows this type of representation or this type of engagement with the parish. You still don't think, in light of Montgomery versus St. Tammany, that's different?
No, sir. And in Montgomery, the issue primarily was that the parish attempted to hire an attorney that they'd picked in lieu of the DA. It wasn't special counsel. It was the parish attorney. And the court was absolutely correct that their charter did not allow them to do that. But there are circumstances, and y'all's charter specifically has a special counsel provision. If you can't hire, if the council can't hire a lawyer to do a narrow subset of legal services, then it means that provision of your charter doesn't mean anything. And I don't think that's what the Montgomery versus St. Tammany case meant. I think what the Montgomery versus St. Tammany case says was that you can't hire an attorney to be the parish attorney to supplant the DA's office. Again, that's just my interpretation of the decision, from my experience.
Well, the charter says, 402 says that the council can appoint legal counsel and approve it for a specific purpose. You don't lay out a specific purpose in your engagement. You lay out, 4 paragraphs of very general services. So I would suggest that's a big difference.
I believe your question should be directed to the council.
Well, that's okay. I'm allowed this. We got the district attorney right here, and this is the district attorney, Mr. Parrott. I'm going to give you the right.
Do you want to get it right, Ms. Sandifer? You're a stickler for doing it right. Do you want to get it right?
I would like. I have some questions for you. Yes, I want to get it right. We are the fastest growing parish in the state. We need help. The attorney that Mr. DeLatte and you entered into contract and a letter of engagement with, you can't handle the full load of what we've got going. And what happens, if a lawsuit happens, okay, and we're thrown into it, and Moody Bolt Law Firm decides they don't want to have anything to do with it. Oops, we have a problem, and we can't afford to have that problem anymore.
That's a hypothetical. Is that happening?
Right, but the contract, your letter of engagement leaves that open. In the past,
go ahead.
No, go ahead.
No, I'll say it's not a problem. If there's a specific lawsuit that's a narrowly tailored issue, that's when, under the charter, you can hire a counsel, just like you've hired the 2 gentlemen that were here earlier and have paid them
exactly
what you've paid them. And gotten the results you've gotten.
In the past, I spoke with you in this council chamber about a reappointment for an attorney for us. And we had a specific conversation about it, and part of that conversation was monetary. And we're not spending any more money than we were at that time that you and I had that conversation, if we engage Mr. Garrett for special counsel.
If we can talk about the money part, I'm not even addressing that. The fact is, it violates your home rule charter. It's as simple as that.
Not if we engage for special counsel.
No. Doesn't say anything about special counsel. It says approve attorney, a special counsel for a specific purpose. Look at the charter. Look at 4.02.
We're happy to name a specific purpose.
What is the purpose is not specific. It's very general, as laid out in 1 through 4 of his engagement proposal to you.
Okay, well, we can amend that. We can
amend what?
We can get a new letter of engagement if that's what we need to get.
Okay.
We can.
In the specific purpose, I'm not sure then what you're going to be. I guess until I see it, I don't know.
I have a question
as this is
for
laid
you.
out, this is. And look, I heard what he said. I just disagree. This supplants everything that the DA's office does for legal representation. It violates the charter, is the only thing I can tell you. Because it does it's not a specific purpose. You think these 4 things are specific purposes that he lays out there? Do you?
Yes, we do.
You do?
Real quick, Mr. Mangus.
Well, how about this? Get an Attorney General's opinion. He cited an Attorney General's opinion as authority. Get a new Attorney General's opinion since the Montgomery case has been ruled on, and see how that comes back if you want to be safe.
Well, I don't think we could do that without a resolution of the council.
Real quick, Mr. Mangus had a question.
Question. I don't think this would have come up. I know we did receive the discount, but I don't think this would have come up had the explicit language been written the way it is. And notwithstanding, Brad does, and Mr. Cascio does answer phone calls and all. But, I mean, if you just read through this, like it says that they can't, Mr. Moody's law firm will not have anything to do with Deer Run, so that forces us into hire special counsel. It talks about conducting unlimited legal research for the parish president or by resolution of the council, but we will not on behalf of any individual council persons. All right, so maybe we do have to request an Attorney General opinion, because we're not the only parish that has the same arrangement with district attorneys. My question would be, is this the norm, the way this new contract is written, or is the norm the way it was before? Because this is very restrictive.
Well, I think the council, I may be mistaken with the dates, but I think the council, parish council, voted to hire special counsel to handle Deer Run prior to that engagement letter. So I think he was just clarifying, hey, you already have an attorney now for Deer Run. We're not handling Deer Run.
Well, the first
which
time
is what you can do under the Home Rule Charter, which is totally acceptable.
The first time I saw this document was way back in January, and I didn't. It just seems specious to me that it wasn't signed until May 14th. I thought you were still attending meetings and we weren't billed for that. And I mean, we need help. We're not lawyers, as you absolutely stated. I'm a school teacher.
And a good one at that.
Thank you. When we write ordinances, my work's better.
What help have you needed that hasn't been provided? I'm just curious.
Well, that's a good point. But the point is it's legally, explicitly, the language is that we can't do it. Brad, out of the
but again,
goodness of his heart, allows us to call him, but here it says we can't.
I ask you, how has it been a problem for you as a council member? I'm just curious.
It's always, you can't do that. We're asking you for help, and it's always, you can't do that because fear, fear, fear. We need help. We're asking for your help. Can you help us?
What are you asking me? What does
More
help?
counsel.
What does help you do? What?
This explicit
Get
language.
the things done that we need to get done.
Not good.
Like what?
We've got lawsuits out there, and because I don't know what I can say and not say on public record, but there's some lack, in my opinion, that's gotten us into these issues. And we need help. Can you help us? That's what we want.
Got to be more specific than that.
We
Mr.
need more
Parallel.
legal counsel.
All right,
Mr.
Coates?
Parallel, I could tell you, I've been coming to these meetings for a long time, and I've sat here and I've seen some of the advice that was rendered. I didn't want to get into all this, but I've seen some of the advice that was rendered to the previous council. And when things went south, the response was, well, that's not my expertise. Well, how is that not your expertise when you're sitting up there accepting checks for that being your expertise?
You'd have to point out to me when that was said. I've never heard that before.
It was definitely said.
Well, I want to also say this.
I will also say this because it was said, it was done in a public meeting that was recorded. I was at a meeting and the council that was here that day was watching the LSU baseball game, and the council member next to him goes, "Who's winning over there?" You know, when you're here, you need to be doing your job and staying focused on what we're doing. Other than that, you're giving us bad advice. We're going to end up in lawsuits, and that's what we were trying to avoid here.
I have a question also, and Brad, I will say, when I call you, you answer. I have to give you that. And when
I
I
agree
text
with
you,
Thank you.
you text
Thank you.
right back. There's no problem with that. But I'm just curious, why are you fighting so hard for the Moody Law Firm? Why wouldn't you want to support us?
I'm fighting for the charter, Mr. Chambers. I'm
So if
fighting
we
for
change,
your charter.
if we change the charter, you would be 100% okay.
That's up to the voters. Absolutely.
No, but are you okay
Absolutely.
with it?
Same voters that
Okay.
elected you, elected me. That's up to them.
Yeah.
But
I just find it.
I cannot sit here and let you take a vote to violate the charter.
Yeah.
You know, without letting you know that you're doing it. If you do it, you do it. We'll see
I'm
what
with
happens.
you. I'm with you.
So-
I just find it ironic that I had, again, and you and I had this conversation on the phone. I've called you several times regarding litter offenders prosecution, and you didn't call me until this was brought up on the agenda.
You're right. And we talked on the phone this morning.
Yeah.
And I never got a message from you many times.
I left you 2 voicemails
And you may have. And I
never got a
explained to you,
call
we had
back.
2 days last month where we didn't have internet service. I get my voicemails via email, and I didn't get it. I'm sorry. I didn't get it. I asked Mr. Erdy. He's known me for years. I call him back. Why would I not call you back? I had no idea what you would want. And I told
And
you,
it had
I
nothing
told
to
you
do
that
with
this
this.
morning, by the way, on the phone.
It had nothing to do with this. This was
Right.
about litter prosecution.
Right.
And you call me back ironically, and you don't get that call.
No.
But you call me when this is on the agenda, and it's just ironic, is all I'm saying.
Because you said this publicly in the meeting last week that I didn't call you back.
Correct.
So I was out of town last week, so today's Monday when I got back. I talked to Mr. Wascom to get your contact
That was
information.
2 months
and
ago I called you, Mr.
No,
Peterloo.
I didn't know about it 2 months ago. I knew about it last Thursday night.
Yeah.
Taylor, did you have
If I
something?
can, look, 'cause I've been in here and I've been the person to say when it's been a very specific zoning question before y'all hired these 2 other gentlemen, where I said, look, that's not my area of expertise, because it's not. You are not going to find any attorney, myself, Mr. Perilou, Mr. Garrity, who's going to be an expert in every category of law that walks in those doors or hits this agenda. It's impossible. But what I can tell you is that's why you have that one section of the charter to say, hey, developing zoning laws, very specific. We're going to hire a special counsel. Great, do it. If I don't know it, I'm going to look it up and I'm going to let you know, hey, I found out your answer, here it is. But there's a reason why you have that in there, and part of our job is to tell you when you're doing things wrong and when you're doing things right. Look, I got a wife and 3 kids at home that want me to be home right now. Okay? But I'm here because I don't want to see y'all get sued and get in trouble by doing the wrong thing. If you want to replace us, I'm okay with that. I just want to make sure you do it right, because I still have that obligation tonight as I sit in this chair to make sure that you do whatever it is you're doing, you do it right. That's all.
And I agree with that, Brad. I agree with what you
It doesn't matter to me. I just want to make sure you do it right.
Be thinking about some action or direction y'all want to go so we can just get out of the conversations. But Mr. Mangus?
Last question. As to the point Mr. Garrett made, if we can get the same services for $6,000, then there's no need to spend more. All right. Mr. Cascio, what is the legal course for this agreement, memorandum, contract, whatever, that Mr. DeLatte signed with the Moody Law Firm? Can it be revisited?
Absolutely.
Because we never signed off. We never voted on it. We had a discussion earlier, and it's really not acceptable. There's things that we need to have in there. I'm not throwing anybody under the bus, but this specific language, explicit language, it says individual councilman can't contact. It doesn't say who the parish council representative is. It might be Mr. Waskin, but it doesn't say.
Right. No, I think that part very well can be changed, because in practice, it hasn't changed.
Right.
In practice, we're not even abiding by that. And I think whenever, as y'all all know, I didn't play a role in any of these negotiations.
Right.
I work here, right? I told y'all, look, I don't care what this says. Y'all need me, you call me.
Exactly,
so
but legally that doesn't
changed.
hold up.
I know, but practically it's never changed.
Factually, it has held up.
Right.
I mean, you haven't been denied any services.
So
no one has not taken your call.
That's fine.
So,
are we amenable to revising this?
I'm amenable to looking at whatever you want to look at on it. I mean, it can always be changed. It can always be altered in any kind of way.
Mr. Taylor, did you have something? I didn't want to leave you out.
So, I mean, Mr. Cascio.
Yes, sir.
You answered the question. If we engage Mr. Garrett, right, that it has to be for a specific reason. So some of the things that we could put him in for special counsel for specific reasons, like zoning issues, or not general counsel, but specific counsel reasons to cover this council, right?
The language is specific purpose.
Specific
and absolutely
purpose.
You can.
So, I mean,
no question you can do that.
I mean, obviously we can get with Mr. Garrett and we can draft that for a very specific person. Then we follow underneath the whole thing, right? We follow what the Home Rule Charter says.
Absolutely.
I mean,
I was looking at this retainer agreement as...
We're going to beat this up for the last 35, 40 minutes that in general it says
55 minutes.
55 minutes. Okay, my bad. Can't see it because I don't have my glasses on. But all we have to say is that, hey, gentlemen, lady, councilman, councilwoman, it has to be specific. So if we engage Mr. Garrett, we need to have it for a very specific reason, or the specific reasons. It's not just one reason. And then we can vote on it or whatever we decide to do. Right? Does that clarify this whole meeting?
I think that's a fair assessment.
Okay, so, Mr. Chairman, can we move to the next, whatever we need to do?
Is there a motion? You want to make a motion?
I don't have a motion right now.
Can I just say one little quick comment?
Sure,
I know
absolutely.
it's been up here a long time. Look, if this council has an appetite to change the charter, then look at that. Look at that with respect to legal representation. Absolutely look at it, but don't just do it willy-nilly and say we come up with a plan on how you want to do it, because and I think Mr. Garrett, he probably has more experience, a lot of experience with that, how different ways it can be done. But if that's something you want to do, then always form a committee to do that, to change the charter, if that's what you think.
Yeah, I hate to give you any ideas, but you could hire him specifically to do that.
I got plenty. The DA's office has plenty of things to do. I didn't write the charter.
Is there any pleasure of the council?
And that's the point that we're making, is that y'all have enough to do and y'all have enough on your plate, and y'all don't need to be concerned with the complexities of the parish council. Y'all have enough going on. So we were trying to get Mr. Garrett in to facilitate that need for the council.
And he's a government attorney. His specialty is government. Is Mr. Moody a government attorney?
Absolutely.
Or is he a trial lawyer?
Absolutely, he's a trial lawyer. Ask Mr. Garrett, he knows him.
Okay, well, I know Mr. Moody, and I've been in court with Mr. Moody.
You don't like Mr. Moody, we know. So I get
but
it.
I think one of the bigger issues here is historically, Moody Law Firm just looking at the bigger picture here, seems to represent the parish president's office more so than the parish council. And, you know,
I can tell you that is always an issue over the years.
Okay, well, we can fix that. We can fix that, but we need help.
Well, think about how you're going to fix it. I don't know. There's always going to be an inherent conflict between council and administration. I'll say always, but it's always the potential for it, right? You don't like what the parish president's doing. You've been elected. You're the legislative branch of government. That is an ongoing, inherent potential conflict.
So I ask you, if, as a councilwoman, as a public servant elected in Livingston Parish, we would like more legal help. We would like input on who we have to represent certain things or issues for us. What would you say to me? I know we need to change the charter, so we don't need to go down that road again.
You've made that request before, I think, and the one time that I've talked to you about it, and I understand that, but Mr. Moody, I know his qualifications, I know his skill set. Y'all may disagree with it, but I think he's here and represents parish government as a whole. That's what he's hired to do. He's not hired to represent the council. He is not. He's not hired to represent the parish president either. He's hired to represent the parish government. But
we're not trying to push that away, by the way. We're not trying to push that away. We are trying to bring, he can still represent parish government, but we would like more help with our council. We are bursting at the seams here.
Let us know what help you need.
I'm asking you. I'm telling you right now.
No, you're saying help, but tell me, you have to going to tell us what help you need, and we'll try to help you.
Well, in the past, with expertise, okay, for example, with expertise, and I can go and show you the letters that were written. I think Mr. Moody stated in a letter that he never advised us on zoning. Do you know about that?
I don't know about that.
Whoa, we got into some big... You're not familiar with the federal judge overturning my zoning? That you're not familiar with any of that?
I remember it generally happening with the lawsuit, but I don't remember the details of what you're talking about. No,
okay, well, the picture that I'm trying or what I'm trying to convey to you is we need help. We need more help to protect our parish, to protect our citizens. Please help. We can't just change the home rule charter. That's a process, and you know that. But we need help. We need more right now.
You need to let us know. You've never called me.
Actually, I have called you.
When?
You didn't call me back.
Oh, come on.
Many times I tried to get in touch with you.
I spent the last 28 years calling everybody back.
I'm so sorry. I spent an entire summer trying to call you when I served on the Library Board of Control. I talked to the lady that answered the phone and told her that I was not getting callbacks and I desperately needed one. And I gave up.
Come on.
I'm not lying.
Is there any pleasure of this council to move forward with anything?
Just really quick, the specific thing that we'd like is, I would like to revisit this contract.
That's fair.
And just remove some explicit language. So
Brad, would you get with John on that?
Not a problem. Okay. And I would also like to change the home rule charter for the future council members that come in and elected. I think that would be wise to do, and I think we should consider that for future council members to be able to hire their own legal counsel for whatever reason.
That's up to the people.
There's a process for that. All you have to do is put it on the agenda, pass a resolution authorizing Mr. Ryan.
An ordinance.
No, it doesn't. Authorize Mr. Ryan to move forward, and then he'll bring an ordinance at the correct time, and he'll line everything up. And a resolution from the council is all that's needed. But of course, an ordinance will be needed, but he'll take care of all that for you. That's what I'm saying. So
appreciate it.
Those resolutions.
You're talking about Jim Ryan?
Yes. He'll do that for you.
And then it has to go to the vote of the people.
And he'll take care of helping us through, walk us through it all the way to the vote of the people. And at that point, we can he won't let you down on that one. That's my experience.
It was tried before, Mr. Shavers. They voted it down. But if you want to try it again, that's.
I think it's a new day in Livingston Parish, Mr. Perilou.
It may be.
Yeah.
It may
Is there
be.
any action, any
That's
more
what we
action?
said the last time, too.
I just want to say one thing, Scott, there. And all this is the results of all these questions and going back and forth. I think you've come to realize that we were unhappy. We were just, and me and you spoke, and I didn't speak bad of somebody. I just said we're not satisfied. I said we want, better help, whether sitting over there or from your office, whatever. And there were a lot of disgruntled people. I happened to be in a position to know, Mr. Dan there, and I said, I have somebody that's very, very good. And that's kind of how we got off the ground. And we just started going back and forth talking, and he kind of just got into the scope of things, and we here tonight doing this thing right now. And it just, we felt like everybody said, no phone calls and no action sometimes taken. Well, no return phone calls. Let me rephrase that. Some council members have told you that point blank. You didn't call back, and we didn't get proper representation.
I just heard the opposite. He returns all y'all's calls. I just heard the opposite.
I'm not referring to Brad. I'm not referring to Brad. I told you today. We talked on the phone. I said, I think Mr. Moody's a fine man. We're not happy with his work ethic. That's what I told you.
I got you.
And that's how I work. And we want better. We want better work.
I understand.
Yeah.
Make one comment.
Well, if there's no action from the council,
John.
I mean, does this council want to take any action? Let's get them.
I think if we do a resolution or something to
Authorize
authorize
to work on the contract?
Yeah.
Yes.
To clarify
That's a great idea.
and
You want to
sharpen
put that
up some of the
in the form of a
language.
motion, John?
Yes, I'll put I move that we revisit the contract signed on May 14th regarding legal counsel by the Moody Law Firm.
For clarification. I'll second that.
Second it.
For clarification.
I tell you what, this is technically not on the agenda for the special counsel, so let's just all agree that we're going to work on that. Is that okay?
I'll make a resolution. I would like a resolution.
It's not on the agenda.
I'm not going to make a resolution for that.
Oh.
I'm going to make a resolution for what's on the agenda. To revisit, I need help with the wording, to revisit contract engagement letter and negotiations with Mr. Dan Garrett.
Let's see, that's, okay. So state your motion again now, if you can.
Can you remember that?
I think I can remember it. A resolution to, revisit is not the right word. What's the word, Brad?
Restructure it?
Restructure
We don't have a contract.
a letter of engagement proposal from Mr. Dan Garrett, LLC. Attorney at law.
To reflect the
What
specific items in 402, as in the Home Rule Charter.
Yes.
Because it has to
There you
be
go.
specific
What is
purpose.
that recording?
If y'all wanted to hire Mr. Garrett to handle a specific issue.
What is 40? Okay.
402 is the Home Rule
That's the
Charter.
section of the Home Rule
So
Charter that allows you to hire special counsel.
what specific issue are we voting on?
Because his letter of engagement doesn't reflect
It's
the
very general.
402B.
Right.
Well, it does. It's just it lists out very general duties what he's going to be doing.
So
like
it does
general
reflect
advice.
402B?
So let me interject.
He references it. I don't think it's a good reflection of it.
Well, first of all, is there a second for Ms. Sandifer's motion?
What is it? One more time,
Okay.
please.
I know, I'm just
Yeah,
getting, now we're going to have discussion.
Yeah.
So-
Ladies, can you help us? What is the motion?
Hold on a minute, John.
Okay.
All right, Aaron, what you got?
A resolution to not revisit, revise the letter of engagement from Mr. Dan Garrett for special counsel as per in the Home Rule Charter, Section 402B.
I'll second.
Without a specific reason?
I just gave you the specific reason.
He's going to revise it to have a specific reason. We don't know what the specific reason is.
Don't know what it is yet.
Can we do that one that way? Can it be worded that way?
Well, it sounds like what you want to do is have him put an engagement letter to
Narrowly tailor what he's being
narrowly
engaged
tailor,
to do.
but without being specific, you just want to be able to get around the home rule charter.
No, it's for the lack in Mr. Moody's engagement letter. So I want to go back and revisit that and use Mr. Garrett, if we can, to fill in the holes where Moody Law Firm cannot provide us services, because there are plenty of times, and Mr. Cascio, you've never denied me a phone call. Let me just say that on record. You've always been very gracious to me.
Thank you, Ms.
And thank you for that.
Yes, ma'am.
But there are times when you cannot be here. That's happened a lot recently. There are times when I can't get in touch with Mr. Moody, and it might be later that day, and it's important. So there is a lack, and it's not. I'm not saying you're not doing your job. What I'm saying is we are growing by leaps and bounds. We're the fastest growing parish in the state. We need help.
All right, we have a motion and a second.
Yeah.
To engage a letter with Mr. Garrett. Is that correct?
That's correct.
Is there any questions regarding that specific motion?
I do.
Mr. Goff.
So I just want to make sure I'm clear. We're fixing to, we just okay to revisit this agreement to clarify it when we all agree pretty much that they are doing all the tasks anyway. And this gentleman stood at the table at the podium and said if they basically are still doing all of those things, if he lived in this parish, it wouldn't make any sense for us to do all of that again and pay him. So we're going to revisit the agreement and clarify it. He's making all the phone calls. Everybody agrees to that. He comes to all the council meetings except for like one or two. And I guess they can probably, in the agreement, make sure that someone from their office is represented here. I just don't understand the purpose of this motion, because it's basically mute if he doesn't have a very narrow, specific reasoning, and he said himself at the podium that he wouldn't have a very narrow, specific reason, unless it's like Mr. Cascio said, and he represents us with the Home Rule Charter and moving forward.
You said we. We agree with you? I don't know.
I was using the same term Mr. Dean did a while ago, we this or we that, so I don't know.
I didn't hear him.
Yeah.
I just
anyway,
heard you.
I'm going to finish what I was saying.
It is just a resolution.
I'm going to finish what I was saying. So I just, as long as I've been sitting on here, both before and now, I have been at both ends of this attorney thing, right? I have been in a case where the administration and the council didn't get along, and it was really hard. Okay, and Mr. Moody was a representative during that time. And even though I did not like a lot of what he had to say, I could depend on him following the law. You had to be very specific with him in those particular incidents, because he was representing government, and that part of that is the administration. Now we have a government at this point in time that the council and the administration gets along, but I'm not going to say that it's not a good effort to go forward with the Home Rule Charter and possibly put that to the people as a vote to have that language changed. But all I'm telling you now is that we don't have issues between administration and here, and as long as I've been on here for the last 6 months, I've gotten the phone calls. Everybody seems like they've gotten the phone calls. We've gotten the advice that we've asked for, but unfortunately, there's a lot of people on this council that didn't get the advice that they wanted to hear, and then we go down litigation and spend $40,000.
That's your opinion, sir.
What's my opinion, ma'am?
What you're saying right now.
Okay, well, look, we got a motion in a second.
This is my opinion that we didn't get the legal direction that we asked for, because the legal direction we asked for, we did not follow. We went down another path that cost this council or this parish $40,000, basically is what nuts and bolts is going to be, for a position that was for nothing, Like the position wasn't paid anything, and we could have waited a year and a half, and that appointment could have been done, and we would have saved $40,000. Not to mention, there's other things that have been asked, and he didn't get the answer that you're looking for, and then to keep bringing up everything that was before this administration and this council doesn't help this parish whatsoever. I really think we need to look at the glass half full. We need to move forward. I think it's mute for what we're trying to do here. This gentleman said the same thing, but hey, if y'all want to...
Why are you so sore at this request?
We have a motion and a second now.
I call the question.
All right, well, I'm going to call for the question. Brad,
I'm getting text messages from President Delat watching. He said he's absolutely willing to go back to the table with us and allow y'all on paper in the contract full access to myself, Mr. Moody, and anybody else, just like we've been doing anyway, but make it official.
I'm going to call for the vote here, but before I do...
No, Mr. Harris.
Hugh, come on up. Can you make it kind of quick? 3 minutes.
Yeah, very, very quick. I don't know Mr. Garrett may be the most wonderful attorney this side of the equator. Mr. Cascio may be the same thing. Mr. Moody may be the same thing. I totally understand y'all may have levels of dissatisfaction with your counselor or whatever, and you can replace them, do home rule shelter. But it needs to be in the record that you understand that you had also asked if Mr. Garrett was going to be the guy to move the meetings to the first and third.
That's coming up next on the agenda.
Okay. Well,
that's next item on the agenda. We're going to pick that up.
I'll be back in.
Thank you. All right.
Read the motion.
Yeah, I am. You say read it again?
Yeah.
It was to a resolution to. Can one of y'all read that? It was a resolution to authorize to get another letter of engagement from Mr. Garrett, I believe, that would be more specific. Okay, that's what it was. Now, I'm going to call for the vote, but I hadn't said anything, but I will say one thing, and I'm going to be the last one to talk here. I know Mr. Cascio has missed a couple meetings, but let me say this. As chairman of this council, there's been a time that he called me that he actually showed up here. His son was baseball coach's pitch, and he was the coach. And we went over the agenda together, and I said, Brad, this is one of those mini meetings that we have that it's really not that necessary for an attorney to be there. And at my request, I said, you go take care of the priorities that are most important. Go pitch ball for your son. So whatever meeting he did miss, I just want you to know he checked with me first. So, Ms. Sandy, you want to call for the vote, please?
Mr. Watts?
No.
Mr. Goff?
No.
Mr. Mangus?
Yes.
Mr. Taylor?
Yes.
Mr. Shavers?
Yes.
Mr. Coates?
Yes.
Mr. Wascom?
No.
Ms. Sandifer?
Yes.
Mr. Erdy?
Yes.
All right, that motion carries. All right, we have another item 7, consideration and introduction of ordinance to provide for amending section 2, Parish Council regular special meetings. This is to change the regular meetings from the first, the second and third Thursday to the first and third, second and fourth Thursdays to the first and second Thursdays of each month. Since
first and third.
Yeah, first,
second and fourth to first and third.
Thank you so much. So now, do y'all want to? Is there an introduction? Is there an ordinance that's drafted for this, Sandy? Do y'all want to table this until you get further with this, or do y'all want to actually introduce this ordinance tonight?
I'd like to make a motion to table that until we get Mr. Garrett's engagement letter back.
Let's use defer. Let's just defer that until you get
let's
that.
let's just defer
this.
this.
Mr. Taylor to defer this until later. Is there a second? Second by Mr. John Mangus. Is there any discussion? Let's call for the vote, Ms. Sandy.
Mr. Watts?
To defer,
yes.
Changing the dates.
Mr. Goff?
Yes.
Mr. Mangus?
Yes.
Mr. Taylor?
Yes.
Mr. Shavers?
Yes.
Mr. Coates?
Yes.
Mr. Wascom?
Yes.
Ms. Sandifer's absent. Mr. Erdy?
Yes.
All right, next item is to adjourn. Is there a motion?
I'd like to make that motion.
Motion by Mr. Taylor to